Well, thank you so much, Anita, and I really want to just say thank you for being here. Thank you for allowing me to be here and everyone taking their time today. My children in the back is what I was going to say. We have like every generation of Americans here together. I just love this idea of the young, the middling, teenagers, a little bit older, my generation, and then we have the older generations as well. But that's really what it takes to bring everyone together for this America 250 celebration. I was asked to talk about the Constitution, and I so rarely get to really just talk in general terms. We're always dealing with very specific issues, very specific questions of law, and in the legal context, the Constitution is a tremendous framework, but really we don't have the chance a lot of times to talk about in general theories. There's going to be moments where I talk about history, moments where I move forward quickly through things, and then moments where I slow down and I really want to stress something. And I want to begin by saying, everyone has heard the 407 years ago, right? Who's here heard that? Everyone, right? It's Lincoln. And it's amazing for me to sit here and say 10 years ago, because that's what it was. 10 years ago, our founding fathers brought forth this nation conceived in liberty. And we're here celebrating that nation, and we're here celebrating the 250th anniversary, which is that. And I'm going to do this through talking about 3 documents and 3 phases of the America 250. First, the Declaration of Independence. Second, the United States Constitution. And then third, just general theory about America 250 and how we carry this forward. So talking about the context of those documents, the drafting and the ratification of the Constitution. And then we'll talk about some of the structure and how that is enduring, and we'll be here for as long as we are committed to it. And that's, I stress that part because it takes our commitment to it. And then the new birth of freedom, which is what I phrased this lecture as, because I think it's so fitting where we live now in 2026 to harken back to Abraham Lincoln, to talk about the conflict, but yet recognize that's what our Constitution is made to do, is to channel that conflict. And so we'll talk about Lincoln and his ideas through 2 of the documents, and I want to call this out as what you were provided here on the table. There's 2 documents, both speeches of Lincoln. One is the Lyceum Address, which we'll focus on. One is the Gettysburg Address. Both, the through line here is the rule of law, popular sovereignty, and then unity through the process of the Constitution. So let's start first with the Declaration of Independence. This is the famous John Trumbull painting. This is where we begin, and frankly, it's why we're celebrating America 250 this year as compared to in about 11 years here in 1787 to celebrate that 250th. So we have this famous painting here. This is when the Committee of 5 who drafted the Declaration, primarily Jefferson, presents this and is asking it to be ratified and approved. It's not actually the signing. Most people think it's the signing, but it's the actual presentment of their draft. And I want to point out, here's a little bit of fashion history for you. I thought this was neat because I thought, when did these go out of style? When did the stockings and breeches go out of style? Well, this is like a historical painting as well, because this would have been one of the last times that they would have been wearing these. Right around 1800 is when they switched over to trousers, as they would call them, and so they had, this essentially is one of the last times they're wearing these in this setting. So there's your little fashion history, and we've got the 5 there depicted are John Adams, Roger Sherman, Robert Livingston, Thomas Jefferson, and Benjamin Franklin. And everyone recognizes that Thomas Jefferson primarily is the drafter here. I want to slow down. I know that's a lot of text on the page, but what I want to focus on here is this. We hold these truths to be self-evident, that all men are created equal. All men are created equal, and I stress that. Then he says that they are endowed by their Creator with certain unalienable rights, and the famous, that among them are life, liberty, and the pursuit of happiness. Now, I want to focus on this for a moment because it's really important to frame how we move forward in our country and popular sovereignty. At this time, we had essentially divine right of kings. We had an intermediary between God, nature, the person that was giving the laws, and that was the king, that was the monarch. And then we had the people. And the king and the monarch would tell you what your rights were, what the law was. And by writing this the way he does, we all recognize now it's a statement of equality among all of us, that no man is a ruler over no one else, that we are equal to each other. But the radical part about this would have been, we don't need that king to tell us our rights. We are given them right now from nature, from God. And so he severs that divine right of kings and the intermediary between God and the law. He severs that entirely and says, every one of you is the person that holds those rights, which would have been very radical in this time to say that, because it was an acceptance that the king was no different, that the monarch was no longer absolutely necessary for a government to support its people. And so that's very important that we stress that and focus on it. And then he pivots to the fact that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. John Locke is the original theorist of this. The Declaration of Independence comes along, and so he severs that idea by saying we're all equal, but then government is here to secure these rights for the people. And that's the idea of popular sovereignty, right? That we get to then pick our government secures our rights. And then the final, after he goes on a long list of things that the king has done and usurpations that have been brought upon the colonies, is this famous ending here where he says that these united colonies are absolved from all allegiance to the British crown, and that all political connections between them and the state of Great Britain is totally dissolved. And I just want to note here, I find it fascinating that he writes the United Colonies as compared to the United States. Right? We think, well, it's the United States, of course, but this is 1776, and so the question of states and were they going to be united was an open question at that time, which we'll see in a moment here. And so in the document itself, it's the United Colonies as compared to the United States. I think that's kind of interesting. And of course, King George, he wanted to fight a war for that and decide whether, in fact, he was necessary to decide these rights. And I'm going to glance over this war because I recognize this is months long of scholarship, so I don't want to do any disservice to it. I'm going to simply say that we fought this war, obviously we won, and then I want to focus just for a second here and foreshadow some of what we're going to talk about later in talking about Lincoln and his declaration. Right at the beginning of the Gettysburg Address, he harkens back to the Declaration. That 7 years ago, our founding fathers brought forth a new nation conceived in liberty and dedicated to the proposition that men are created equal. And so the point is that this has been with us and remains with us. Lincoln focused on this for a particular reason, and we'll talk about that later, but that's really the through line of our government, is how do we channel popular sovereignty, individual rights, into a system that can govern everyone and not disparage or eliminate the minorities, which is what we'll focus heavily on the Constitution here. So we fight the war, we move into the Articles of Confederation and the United States Constitution. We start first with that history of how do we actually arrive at this Constitution, and we begin with the general theories that are in the Constitution. There's two of them that I want to focus on here. First is the controlled majority rule. And I want to say controlled majority rule because it's certainly right that our Constitution provides majority rule as the basis for all action, because without that, government really is not justified. If they're always acting for the minority, well, then certainly we don't recognize that as the popular will of the people. But if they also are unchecked, that is when the minority becomes disparaged repeatedly. It's the basis of that popular sovereignty with the control over that. And the other one, and this one's probably a little more nuanced, and I'll just try to go through it as I can, is we see the document now as the supreme law of the land, as it states. But the document itself, through its various apparatus, creates that unity in and of itself. It requires the people work together, even though they disagree. It simultaneously separates power, but then makes that power come back to itself and work with each other. And we'll go over that in a little more detail in a minute. So I want to reference the Articles of Confederation and mention the fact that this is what we had originally. This is in the Daughters of the American Revolution book. I love the fact that that's being handed out. It's in there. And these are the first article is really superfluous, but the second and third article are relevant here because this popular sovereignty at this time was given to the states. It was not given to a federal government. And And so they recognize all men are created equal. We need to have some form of government, but we're going to vest that authority with the states. And then they will become this firm league of friendship. And the reality was that the states were self-interested. They were not getting along well. If you look at this history at this time, the states were acting horribly to one another, and the citizens, right, Rhode Island particularly, would say, hey, if you want to do business and you're an out-of-state business, we are going to tax you. If you are an in-state business, we are going to give you these incredible rewards. And so if you're, obviously Rhode Island's small, and so if you're doing business from out of state, which was a lot, we're going to make you pay a tax to Rhode Island to do that business, even though it's just down the road. And so that was just an example of some of the things that the states were doing that was self-interested and not loyal to the national cause. So then we move into the drafting and the ratification of the Constitution. James Madison, one of the early people that recognized we need something new. We cannot continue with the Articles of Confederation. It is insufficient to provide for the national good. The states may be doing well, but the national good is what we are losing here. And so he writes in 1787, The Vices of the Political System of the United States, and then calls and is at the Constitutional Convention. He's known as the father of the Constitution. There's two reasons for this mainly. One is very practical. Right? He comes up with the Virginia Plan and then presents it with Gouverneur Morris, who's the governor at the time. But in reality, he shows up early to the Constitutional Convention. And we all sit there and go, well, what does that have to do with it? They changed the rules so that a person not being there was no longer a veto to the rest. So they basically said a vote of the majority of those at the convention is going to be able to pass something along, whereas before all of the conventions had been of the colonies themselves. And so if you chose not to be there, you were no longer a no vote, you just weren't heard. And so some of these states didn't show up until late. Meanwhile, Madison is there presenting the Virginia Plan, going through the details of his plan, which is shockingly similar to what we have now, and then able to get some movement. And then finally some of the other smaller states show up and say, wait a minute now, we want to be heard. And sure, they had their due course, there was the compromise, but that's why partially he's known as the father of the Constitution. Another reason, he's the clerk. You have, where's George Washington in the room? Raise your hand, Nelson. Yeah, we got George Washington in the room. George Washington was the presiding officer at the convention, but Madison was the clerk of the Constitutional Convention. We have his notes now that were published years later, and so he takes fastidious notes of what is said, who rises, who responds, who talks, and those notes are wonderful to give us an idea of what was being said in the actual convention itself. So those are the reasons why he's largely known as the father of the Constitution. It is then ratified, I should say it is passed out of the Constitutional Convention on September 17, 1787, and then they go back to their individual states to have the ratification discussions. Out of that, to me, is one of our premier contributions to the world. And I say that, I know it's a bold statement, but our premier contributions to the world is the theories of the Federalist Papers. Sure, they were written by 3 individuals. Sure, they were published on a serial basis under the name Publius, but if you take them as a whole, they are a masterful work at representative government. And frankly, some of these ideas are not new. You have the Greeks that are wrestling with how do we manage democracy? How do we manage all the people being heard without it turning into majority tyranny? And Madison, Hamilton, and Jay all condense that down to very basic principles of understanding. Now, one of those being faction. I'm going to slow down here a little bit and talk about faction because it's so important to how our Constitution divides this. I give this talk to 4th graders, not this very talk, I will say, 4th graders, high schoolers, more advanced age individuals, and the reality is it's hard to give this in the same terms. But when you talk about faction, if you break it down, everybody gets to understand it, right? Who likes the color red? Who likes the color blue? Whose favorite color is green? Who likes soda? Who likes pop? Who likes juice? They're all divisions among us. And so faction is going to be present in humans. And Madison writes this, he says, as long as the reason of man continues fallible and they are at liberty to exercise it, different opinions will be formed. Now we feel that, right? We see that on social media all the time. And the point is that we are free to exercise our thought. We are free to exercise our opinion. But at this time, it wasn't necessarily confirmed because we didn't have the First Amendment at this time. It hadn't been passed yet. And so he's identifying this concept of we will have different opinions and we must preserve those differences of opinions in a way that majority rules, but yet if you're on the opposing side of that, your voice is heard too. Because if you go into strict majority rule, that essentially turns into tyranny when 49% is constantly unheard, unfelt, and abused, and 51% can do essentially whatever they want to them. And so I think that's really important for us to understand. And so his solution to this is novel. And he says, let's extend the republic. Let's have a vast republic. More voices are necessary, not less. More opinions are necessary. And then pass those through a chosen people, which is in Congress, which is in the executive, and they can refine and enlarge that general base theory, right? And we understand that now. We have got representative of Senator Young's office here. We have an idea. We want to pass that on to her. We want to pass that on to Senator Young. He's a Marine after all, so he can be trusted. I have to throw that in just for her. But my point is, we get to have that voice with them, and they refine and enlarge. They hear all of these, and then they pass them along. And that is that then controlled majority rule. What is out of the Federalist Papers ultimately is they're trying to argue for this one great United States political, commercial, military, and social system, which was somewhat new at the time. It was really drawing everyone together and saying, we are in this together. And so then the strict history here, we have, it starts over here on the left. Delaware is the first to ratify, and then after you get to New Hampshire, officially it becomes the law of the land, and then there's the stragglers there. And so Rhode Island does in fact adopt it, even though they were being terrible, but I would note, it took them a little while. 1790 after most of them were in 1788. Now we start within and move into the structure of the document itself. Everyone knows the preamble. In my preparation for this, I had the opportunity to speak to my grandmother. And I don't remember exactly how old she is. I want to say 88, 89. My mom's giving the thumbs up that that's close enough. And I started telling my aunt who was there and her a little bit about what I was going to talk about. And she goes, I remember learning that in high school. And I said, and that's the beauty of it. You learned it in high school. I learned it in high school. My kids will learn it in high school. It's passed on from generation to generation. So we have the preamble, and that sets up some of the general theories of the document. And then we have articles, and we have amendments. And the first three articles are listed here because these are the big branches of government. So we've got the Legislative Congress in Article 1, President and Executive in Article 2, and then SCOTUS and what they call inferior courts in Article 3. And essentially what this structure of the articles lays out is the various offices and the system brought into by the words on the page and the embodiment of the people that are in those offices, the norms and the traditions, our system of government, our system of rule of law as we know it. And that is how we then interact with the government as it is. There's the remaining articles here, relationship among the states, constitutional amendments, debt and national supremacy, and then the ratification. And I do want to just pause and say, the fact that they thought about amendments, I think, is important. Because perhaps if you had this divine right of kings, if you had a monarch saying, I am the law, and that is that, the last thing they want to talk about is amendments, because they're going to say, well, why do we need to amend it? Whatever I say goes. Mm-hmm. Whereas they recognize that this is the system, this is enduring, and we need to have a system in it to add or detract or take away from, change, alter, etc. by way of the amendment. So I think that is important to note. We then have the first 10 amendments, and Madison there with his cool glasses drafts the first 10. He really takes and assembles the first 10, and that's what we know as the Bill of Rights. And I want to focus here because we think of that this was just almost ordained, right, like Moses down from Mount Sinai with the tablets, but really it was not. It was people submitting ideas to Madison, Madison assembling these ideas and saying, that's not a good one, I don't like that, I'm going to keep that out, or I'm going to make this one say this certain way, and then he crafts these first 10 amendments that we know as the Bill of Rights. And so the first, I have 5 here, are the freedom of speech, press, assembly, and petition, keeping and bearing arms, quartering soldiers, search and seizure, double jeopardy, self-incrimination, due process, government takings. I do have to apologize for the lawyers in the room. We're not going to talk much about the amendments. Everyone might get to hear at some point about my Fourth Amendment jurisprudence, but it is not today. If you want to talk to me after that, you can. And then we have the next 5 amendments, and we have 6 through 10 here. Rights of criminal defendants, right to jury in civil disputes, excessive bail, and cruel and unusual punishment, the unenumerated rights, and the reserved rights to the states and the people. Pause here again for the 10th Amendment here. Again, the theory is all men are created equal. The theory is popular government, popular sovereignty. The people hold these rights, not the government. The government's there to secure the rights. So again, that is contained in the document itself by saying, here's the government, here are the amendments, here are your rights, and everything else listed somewhere else, meaning not in the document, is reserved to the states and the people. And so they acknowledge right there in the document, we're not changing the fundamental structure of the Declaration of Independence. You still have your equality, you still have your rights. We're just making sure it's clear these are the areas the federal government's going to be discussing and executing power on. Want to look at it this way in terms of how this today impacts us. Sorry, Nelson loves the Third Amendment, the quartering troops, but I'm not going to talk too much about the Third Amendment. I have the first 2 as the political amendments. We recognize this, right? Freedom of speech. Whether I like or dislike something, I get to say that. I get to petition my government. I get to assemble like this. And so these are the political amendments. And ultimately, Second Amendment is probably a political amendment. Some might disagree with that. But the reality is, if the government is being tyrannical, the citizens need to have the right to keep and bear arms. So it is ultimately a political amendment because if someone takes power and tries to take over, we have that as a recourse. You then have the next few amendments, skipping over to the third, and I look at this as the 4th through the 7th, as the jury amendments. These are the things that aren't necessarily inherent in the document. We take them for granted now, but these amendments clarified that Article 3, Section 2, right to the jury trial process, must be done in a certain way. So if you don't have the amendments 4 through 7, that jury process doesn't function. And the way this breaks down very clearly is, if you don't have the 4th Amendment prohibiting unlawful or unreasonable search and seizure, well then you're going to have officers doing whatever they want, however they want, and then they can present that to a jury and say, well, obviously they did it because I saw them in their home, I could do whatever I wanted and observe them in any way. And then the jury will not know any better and adopt that. But you have the 4th Amendment that says we have these limitations, you must go through these processes, and then you can present it to a jury. So I just stress that the 4 through 7, it really solidifies those jury, the right to a trial by jury. Additionally, I want to focus on 4 through 7 for just a moment too, because Federalist 78 talks about the role of courts, and we'll talk about it in a minute, but it's a foreshadowing for how the court could be involved in this. And this is quoting back to Madison about faction here, because those first 10 amendments really is saying that the cause, faction are thus sown to the nature of humans, and we see them everywhere brought into different degrees of activity according to different circumstances of civil society. It's trying to take account of all these various areas where faction will exist and saying this is what the government can and can't do. These are the limitations that government has as it relates to those factions, and then it channels that popular government through the Constitution. I already talked earlier about unity through disunity, and the reality is that it disaggregates the power through these articles and through these amendments. And what I'd focus on is simply saying you have the House, and that's the House of Representatives, you have the House that is more of a popular form of government. Every 2 years, there's regular elections, and that is most directly related to the people. Then you have the Senate, which is every 6-year terms. And that is a different type of individual that's going to be elected to that office. Some would say a little more longer thinking, future thinking. I look at Senator Young, but I don't know, maybe. And the point of it is that it's going to attract a different type of person into that office and having different interests. And so that legislative process is split by the bicameral system so that you can have the House turning over that popular sovereignty on a much more regular basis and the Senate moderating or mediating that in a different rate altogether. But focus then and say none of them can do anything if the president then is not aligned saying we will or will not sign that bill into law. So that's how it separates all that power out of the legislative, executive, and then also the judiciary. And then it sets them against each other at times, but requires them to go back to each other at times as well. So there's constant conflict, but that's the system that we live in. That's the beauty of it, is that it puts that conflict into the system that we have. And there's essentially a 5-part framework for what I've discussed here. It's essentially that the Constitution acts as a legal framework, a policy framework, there's the institutional framework, there's the political framework, which establishes how we are to interact in a polity, and then there is the unity base that this is a single government framework. So there's that 5-part framework that I think is helpful to think about. It also does it by the checks and balances, which are the famous. And as I've indicated, it separates the types of power. And I want to stress and focus here that the Federalist Papers recognize that there isn't like this finite amount of power, so to speak. There is not like a set or a bank account with power in it, and everyone's competing over that same amount in a zero-sum game. There are different forms, and then there is a different amounts. So the forms would be the law-making process. That is different than the judicial review process, which is a different form of power. And then the executive is the enforcement of and the sword of the community, which we'll see in a second. But then within those, there is that division of the actual amount of that type of power. And again, I just pause here too to say, when I go about my daily business and I have individuals that are arguing in front of me, occasionally I'll get an argument that really sounds like a legislative process, right? They're like, Judge, we want you to do this. We want you to create this new cause of action for people, right? We want you to make this new thing. And I just sit there and I think about this and I go, that sure sounds like a legislative process, right? Or this sounds like an executive process that they're trying to ask me to do. And I have to remember, my role is the judicial process. I am within the judiciary. And those are valid powers. Those are justified powers. But is it for me to then be exercising that power? And I would hope and I assume that the other folks in the other branches do the same thing. That they would sit there and say, this seems like a judicial power. We need to leave that to the judges. This seems like a legislative power, or vice versa. We need to leave that to the other branches. Just observe that. I mentioned Federal 78 here, and the executive not only dispenses the honors, but holds the sword of the community. The legislature not only commands the purse, but prescribes the rules by which the duties and the rights of every citizen are to be regulated. This is the quote that's well on its way to saying, and then there's the lowly judiciary. In Federal 78, he says, and therefore it can be well and truly said that the judiciary is the weakest of the branches for these reasons. But in that, I think is very fascinating, because the role of the courts is only called into play when someone is aggrieved. Right? I don't get to just say, here's what I'm going to do in the community right now. I don't have that authority. Judges don't. They only act when someone presents a case to them. And that limitation on their actions and their power is very important. Because if you permit them to just prescriptively say what the law is, what it should be, without a case or controversy in front of them, well, again, they are exercising a different type of power and authority. And so I think it's very important for them to say, we have this limitation, we are only called in at certain times, and that is when we act. That is when we get to review what the Constitution does or does not say. Not at all times, not at all places. And then I put Federalist 47 in here for one particular reason. I mentioned majority rule, and I mentioned the controlling of that, but right at the beginning, Madison is talking about here that it does not matter your form of government. A monarch, an oligarchy, pure democracy. It does not matter your form of government. But if all the types of powers that government can control are assumed into one group, that is the definition of tyranny. Right? And what that means in concrete form is that the judge is allowed to decide what the law is. If the judge is allowed to enforce that law on his own, and then if the judge is allowed to review that law and say, I've done it right, I've done a good thing, I've accurately said the law, you broke the law, and by the way, I get to say what the punishment is, that is the definition of tyranny. And it could be anything. The legislative branch does the same thing. They get to choose what the law is, then they get to enforce the law, and then they get to review the law. That's the definition of tyranny. And it can be done by the majority and the masses too. It's not just if it is a single person or a single branch. So that's why I left Federalist 47 in here. Now pivoting and transitioning to our next topic where I want to focus, you have Madison here that writes, famous line, ambition must be made to counteract ambition. But what is government itself but the greatest of all reflections of human nature? Right, we think, well, that's government, that's that. But we realize we're part of that. We are that government. And the reflexive of that, as Madison points out, is the government is us. We decide who's in that government. We decide how they act next. And some would say in this day and age, it's hard because it's distant. We have wide range of representation in our House and our Senate, and it's hard to have that voice. But the reality is, it's a reflection of, and some people say politics is downstream from society for that reason, because it always starts with us and it's a reflection of us. Now the part that I want to transition to Lincoln here is that ambition must be met to counteract ambition. You look at Lincoln, and this is the two documents that you were provided. It was on the sheet that looks like this. You've got the Lyceum Address, and then you have the Gettysburg Address. And the Constitution was designed because the founders understood human nature. Lincoln later warned that same human nature through faction, ambition, passion, and contempt of lawful restraint could destroy the system from within. We begin with the Lyceum Address, and he's noting on the corruption of the rule of law, the mob violence. On page 2 of the handout, he writes about this, where he says, if destruction be our lot, we must ourselves be its author and finisher. As a nation of freemen, we must live through all time or die by suicide. So he's identifying that these great United States are only going to be destroyed from within, not from without. And that's when contempt of process comes up. And he offers then the solution, and he calls this the political religion of our nation, and that is reverence for the laws. And the reason I love this essay is you read it now, and other than the small things about Vicksburg and the hangings and the burnings, which I recognize are not necessarily of this time, it could be written yesterday, and we would sit here and say, that is so profound, and that is so applicable to our time now. And when you look at this through line that I talked about, again, popular sovereignty, the rights are with the people, no longer needing the monarch. Thomas Paine wrote, as in absolute governments, the king is the law. So in free countries, the law ought be king. Right? And that's him saying exactly what Lincoln is talking about. The rule of law is the most important thing, and let that reverence be our political religion. He recognizes, though, there are bad laws. We need to, as best we can, repeal, change, and reform those bad laws. But do that through lawful process and not through mob rule, not through contempt of that authority. And I think this is the real genius of the Lyceum Address, in addition to the next comments that I talked about. But for the people in the mob, he identifies that that's a problem. Because he says, you have to remember and remind yourself, you're in the mob today, but tomorrow you may be the one that the mob is after. And so he's like, look, you can't be that person in the mob because you have to be leery of what they're going to do. But I think that's bracketed off by certain individuals engaging in that or not engaging in that. But this is the part that really, really deteriorates our country, is when normal people, just the run-of-the-mill folks that live in their house, want to have property, want to have a job, don't believe that their government is going to be able to protect them because the mobs are going around, or there are people that are allowed to break the rule of law. It alienates them from their form of government. They no longer believe in that form of government. And so therefore, if they don't believe in it, and you have the mobs, or as Lincoln talks about, someone who might seize authority, then no one is there to resist. No one is there to say, we must have this Constitution endure, because everyone no longer believes in it. And he says, if the people believe in the rule of law, they will be sufficient to stand up to the mob or to stand up to the individual that tries to take authority in improper means. But if you allow that alienation, that's where you have a complete destruction of the system. I love this part of the Lyceum Address. This is where he talks about the warning of someone of sufficient skill and ambition and the exploitive leaders. On page 7 of your handout, I'm going to read it because it's so brilliant. Towering genius disdains a beaten path. It seeks regions hitherto unexplored. It sees no distinction in adding story to story upon the monuments of fame, erected to the memory of others. It denies that it is glory enough to serve under any chief. It scorns to tread in the footsteps of any predecessor, however illustrious. It thirsts and burns for distinction, and if possible, it will have it, whether at the expense of emancipating slaves or enslaving freemen. And he goes on to say, do you think a Napoleon, an Alexander, and a Caesar would be happy with being president? No, of course not. They would burn the whole system because they believe they are important enough for them. And that's where he says, we as the people must believe in our rule of law, believe in our system to be able to fight off that person that does that. And I think that's the brilliance of the Lyceum Address, is he diagnoses, he identifies, he offers the solution, and that is that political religion. And then he also warns about what could happen if there's an alienation of the people from the constitutional structure. And I want to leave time for questions, but to conclude here, I've left the Gettysburg Address on the last page, and I had thoughts of just reading the Gettysburg Address, because frankly, you really can't get any better than that. I'll try to add or detract as I can, but it is really with great humility that I offer this. And I want to again state my gratitude for being here in the Historical Society, because the exact thing that Lincoln is talking about is the exact thing that we here are doing with America 250. It's what I will leave you with, and it is what the Historical Society is doing every day when they are dedicated to the work set out before them. And so Gettysburg is given as a commemorative speech to honor the cemetery that is being dedicated. And there's various drafts of this, various forms. People wrote down the speech as it was given. There were drafts that he had made before, drafts that changed things right up on the railroad ride out there. And it's so brilliant in the way that it frames the past, as I've talked about a little bit, calls back to the Declaration. It then confirms what they're doing at the cemetery, that this is just, this is right, this is honorable, but then also says it's so devoid of what the folks have already done. Right? And in our context, what we're doing here with America 250 is right, it is correct, but it's also going to always be lacking because we cannot go back in time. We cannot be the founding fathers. We cannot be the people that were fighting for women's suffrage in the past. We have to just honor them by doing what we can now. And so that is when he says, we cannot dedicate, we cannot consecrate, we cannot hallow this ground. Those that died here have done that for us. And then, this is really what I want to leave you with. It's the forward-looking nature of Lincoln. Now, Lincoln was known to suffer from a little bit of depression and or just lowly thoughts. And I've always been struck by that because I do think deep down from reading all of his works, he was an optimist. Right? That he believed in our country, he believed in our system. And so he's then forward-looking. So he pivots from that we cannot dedicate this ground. And he says that it is for us to finish this work and take upon the unfinished work set out before us. And that's really what America 250, in my opinion, should be. I was called upon to speak about the Constitution today. I've done that in brief form, recognizing that there are vast swaths of things I left out. But it's that rededication to the cause of our American system of government that I wanted to focus on with Lincoln here. And we are to take increased devotion to the American system as it is. And so on the page here is really that last line that I think is so important, and my sons can attest to this. I read them the Gettysburg Address from time to time. Sorry, Peter. Sorry, Henry. And there are times where I get a little emotional thinking about what has happened in the past, where we are now, and then I look at them and I think where we are today and where we will be. But that we here highly resolve that these dead shall not have died in vain, that this nation under God shall have a new birth of freedom, and that government of the people, by the people, for the people, shall not perish from this earth. And that is what America 250 is all about. Be dedicated to that cause and take increased devotion as Lincoln calls us to do. So with that, I'll open it up to questions. I thank you very much for your time and attention here. And by all means, question away. Yes.
The 5-4 Supreme Court decision, are they following the Constitution or their own political beliefs?
Well, I don't want to talk about necessarily the individual decisions, but a 5-4 decision is what essentially our structure is set up to be. Now, there's a lot packed in there. Let me break this down. First is the Constitution does not require there be 9 justices. That is essentially set up by policy and practice, and obviously legislation, but it doesn't require that. So when it's 5-4, you're necessarily saying 9, and that is the system we have. When it's 5-4, the 5 that decided in the majority decide what the Constitution says or does not say, and what the law of the land is. But having said that, that is essentially what I talked about, where you have it channeling that power into the Supreme Court, but yet then there is recourse by Congress, the executive, and ultimately the people, because if it's a 5-4 decision and it's so manifestly against the character of the document or the will of the people, there can either be an amendment to the Constitution or a change to the legislation that then gets around or circumvents or alters that effectiveness of that decision. So, as best I can answer your question, it's a valid decision if it's 5-4. The majority won on the court in the opinion, and then necessarily not 9 is in our Constitution, but what our policy and system is. Does that answer your question?
Pretty much, but it seems to me like, if you're following the Constitution, it should be a 9 to nothing, but, maybe that's just too simple.
No, I understand what you're saying, and I think that, I think it's a great observation, right? That the words on the document should be self-evident, and that they should be obvious and easy, but the reality is life is not so straightforward. And I would also say, as Madison pointed out, if you're going to have 9 people, if you're going to have 9,000 people, you're going to have a difference of opinion about what those words on the page mean. And so I can understand why you might say, well, it's black and white. Why isn't it 9-0? But the reality is there's going to be 9 different opinions about what that says, and they're justified in channeling their authority. But again, even in the choice of those justices, our Constitution is brilliant in this sense because the executive picks and then the Senate confirms. And so you, right there, have some check on what is and what is not. Now, I would argue the Senate, doing away with filibuster for judicial appointments, eroded that minority voice, because up to that point, you had to take into account the minority voice in a more prudent way, because you had to have a super majority to get that person on the court. And so, you know, if you have to take account of that minority voice, I think you're truer to the Constitution. But you know, that's a policy decision for the Senate to make. Great question.
You've convinced me that, regardless of my opinion, it is a good system.
Amen to that. Amen to that, yes.
Any other questions? Well, I think Judge Sarber would be happy to answer any questions as you leave. Don't forget also to pick up your book on the Constitution and your nifty pen if you want one. I have 3 ladies I need to print for, and I'll do that now. And thank you again, and we'll see you next time.
Thank you.